So we've talked about the different types of titles involved with real estate. Now we take a look at the different types of deeds. And, this is an area where I think a lot of people just don't understand or don't realize. But there are many different types of deeds. Okay. I think most people just think there's like a deed, one deed, and a deed just transfers property from one to the other, which is true. In fact, all deeds and we're getting ready to talk about several types of deeds. They all do the same thing, and that is, the purpose of a deed is to transfer ownership rights from one person to another. We even say a lot of times, I will deed this property to you. But what's the difference? And first of all, how many types of deeds are there, and what's the difference from one deed to another? And that's what we need to talk about in this module. I will say, if you look at that second bullet there, in order for a deed to be valid, it must be signed by the grantor. Okay, not the grantee. Remember, grantor is the seller, but you notice, the buyer does not sign the deed. Only the seller will sign the deed, because once that seller signs it and it states on the deed, as you'll see as we go through, I'm transferring the ownership rights from myself over to so and so. That provision, that clause, that granting clause you'll see here later, is what transfer those rights. All the seller has to do is sign it, and those rights are transferred. So there's nothing for the buyer to sign when it comes to the deed. Okay. So again, the purpose of the deed is to just transfer the rights, the bundle of rights of ownership from one to another. But what is the difference between one deed and another? It's dealing with the guarantees and warranties that the seller is making concerning title or potential defect in title. So depending on what type of deed you get, it really determines how much guarantees and warranties you get that there's not going to be any issues with the title to the property. Okay, so let's talk about this. First you see there's some key points to make sure you know. Make sure you know the difference between the grantor and the grantee. Right, the grantor is the seller, the one that's actually transferring the rights. The grantee is the buyer that's actually receiving these rights. And then, we already talked about the different types of deeds. So let's start with the general warranty deed. In fact, I'll just go ahead and tell you, the first two deeds that we're getting ready to talk about are by far the most common, at least as far as we as real estate agents are concerned. When we are representing those buying and selling real estate, it's typically going to be one of these first two deeds. Doesn't have to be, and it's not always the case, but these are the most common, the first two. And my guess is this first one, the general warranty deed, is probably more common than the second, which is you see used a lot as well. And what we say the difference between one deed and another would be? The extent of guarantees and warranties you're getting as the buyer from the seller concerning potential defect in title. So when the parties agree to a general warranty deed, and this will be written into the contract. In fact, typically, certainly in my market where we work, it's already pre-printed in the contract that the seller will convey this property to the buyer via a general warranty deed. So it's already pre-printed in the contract. Doesn't mean it can't be changed or modified, but that's what you're going to get typically. All right, so what does that mean? So if I'm selling my house and obviously grant a general warranty deed, what I'm telling the buyer is this. If at any point after you buy this property, defect in title should occur. Things we did not know about when you bought it. So we got issues with the title that have popped up from the past. Then I, as the seller, am responsible for that. I guarantee you, buyer, there are no defect in title that took place during the time that I owned it or even during the time before I owned it. So I'm responsible for anything that may pop up, whether it be prior to my ownership or during my ownership. Then I'm making guarantees that that's not going to happen. So in other words, the seller saying I'll be responsible if any defect in titles are determined after the sale. Okay, so honestly, seller, you're making an awful lot of guarantees and warranties when you convey property this way, because you're not just guaranteeing that nothing happened with title while you owned it. You're guaranteeing that nothing happened even prior to your ownership, and you don't have a clue what could have taken place with this deed or property prior to your ownership, because again, a lot of this stuff may have never even been recorded. So if things that are not recorded, we won't know about, certainly at the time you close, but it don't mean it can't come to light at some point in the future. So how does the seller protect themselves if they're going to make this amount of guarantees and warranties? Seller, if you're going to use a general warranty deed, I would hope you have a owner's title insurance policy. Because obviously if you have title insurance, then that insurance will cover you for any potential issues, right? So anytime I'm representing the seller, before I would agree to let them use a general warranty deed, I want to make sure they first have an owner's insurance, owner's title insurance policy, so that they're covered if something happens. Otherwise, this could be a very, very expensive problem for you down the road. But if we don't use a general warranty deed because we think that's just way too much guarantees there, then another option, actually, before we get into that, we look at what some of these warranties that the seller is making. I was going too fast here, but let's look at what some of these warranties include that will be covered. But all defects in title, regardless of when they arose, again, whether it be during your ownership or prior to. But then you see a list of things, some examples of things that the seller's responsible for if any of this stuff pops up that we did not know about when we close. Mortgages, tax liens, title claims, judgments, and so forth. And that's not an all-inclusive list. That's just some examples. So again, seller, you're making an awful lot of guarantees when you sell your property with a general warranty deed. We just talked about everything pretty much on this slide already, so I just kind of got ahead of myself. But again, seller, you're on the hook. You're making all these future guarantees about things that you didn't even know about potentially prior to your ownership. Just beware. But here's the second type of deed that is also very common. I'd say the second most common behind the general warranty deed, and it's called the special warranty deed. In fact, oftentimes you may even hear it referred to as a limited warranty deed, but the legal name is special warranty deed. Okay, so what's the difference between a general warranty and a special warranty deed? Well, if the seller decides to grant or to sell their property using special warranty, now what the seller is telling the buyer is this: I do make guarantees and warranties that there are no defects in titles, there are no other undiscovered liens, there are no issues. I guarantee that, but I can only guarantee it that that none of that took place during the time that I owned the property. I cannot and will not be guaranteeing anything that may have taken place prior to my ownership. So remember, the general warranty is you're guaranteeing everything that happened before you owned it and while you own it. Special warranty, you're only guaranteeing things that may have happened or hopefully not happened just during the time that you own the property. So, y'all, as I was saying with the general warranty deed, y'all, and this is something I look into with all my sellers anyway. Y'all, if my seller did not buy a owner's title insurance, y'all, not just the lender's policy. Remember the mortgagee's policy, y'all, that covers the lender. I want to make sure my owner is covered. So did you also purchase an owner's policy? Now, how do you know that? Y'all, if you look at the settlement statement from when they initially bought the property, however long ago that may have been, y'all, on the settlement statement, it'll show what y'all, so if they bought title insurance, it will show up on the settlement statement, right? Y'all, all the debits and credits, everything that took place with money-wise with that transaction will show up on the settlement statement. Well, if you look on that settlement statement and you just see one line that says title insurance, chances are, I can about guarantee you that's going to be the lender's policy, because that's not an option. Y'all, that's mandatory. Y'all, the lender's going to require that, okay? They don't even usually talk to you about it, just part of your closing cost. But what you want to look for is hopefully you'll see two lines that show where you actually bought two policies. So if you bought two policies, then you know one of them's the lender's policy, but the other one is the owner's policy. If you just see one listed there, y'all, chances are, unless that seller, when he bought it, paid cash, I can about guarantee you that's just the lender's policy, which means the owner does not have a policy. Title insurance policy. So if they don't have title insurance and the contract already, y'all's pre-printed in the contract that we're using a general warranty deed, y'all, I always recommend to my seller we change that. Let's change it from general warranty to special warranty, because if you're not insured against any defects in title, how can you make those kind of guarantees and warranties to someone else? Especially the extent of guarantees that come with that general warranty. So I would go with something that's not so detrimental if something happens, like a special warranty, because surely the seller should know if something happened during to their property during the time they own it. But as long as they have title insurance, an owner's policy, it really doesn't matter which warranty they use, or which deed they use rather, because they're insured against defects anyway. So it shouldn't be that big a deal. But general warranty is usually the most common deed, and then right behind it, I think, is the special warranty deed. You'll see that a good bit. In fact, some contracts, they actually have it pre-printed in there that it will be a special warranty. So, y'all, it's important to read these contracts to make sure we know exactly what our client is agreeing to here. Now, there's some other types of deeds that you see used for different purposes, okay? These are not typical type deeds in your traditional buying and selling of real estate, okay, where real estate agents are involved. They can be, and sometimes they are. It's just not real common to see any of these deeds with your typical buying and selling. But the next type of deed is what we call the quitclaim deed. Y'all, that's a very common deed as well, but it's not usually or typically used when you're buying or selling real estate. Y'all, it says this deed is used when somebody is just releasing their interest that they own in the property and giving it to somebody else. In other words, I have a house and I'm going to give it to my daughter, for example. She needs somewhere to live and I don't need it right now, so I just give it to her. Well, then, y'all, you might want to use a quitclaim to do that. Now, with a quitclaim deed, this one does not have any guarantees and no warranties against title defect. So basically, if I'm the person that owns it, I'm giving it to my daughter. I'm saying, look, you can have it. It's all yours. Just understand, I'm not making any kind of guarantees that somebody won't come up later demanding the property back, or there's not any issues with title. So there's no guarantees and no warranties. Y'all, I remember that. In fact, chances are, if you're ever asked a question, which of the following deeds would carry no guarantees or warranties, expressed or implied, of any kind, y'all, something along those lines, I can about guarantee you the answer they're going to be looking for is the quitclaim. Y'all, quitclaim has no guarantees, no warranties. They're just saying, whatever I've got, you can have it, and I'm done with it. That's it. Okay? Y'all, there are other deeds that have no guarantees and warranties as well, but this is the one they tend to lean on when it comes to that. All right, anyway. A tax deed. Y'all, if you should ever go to a tax sale, bid on property, you're the highest bidder, then they will issue the rights to that property via a tax deed. This happens obviously, if someone's not paying their property taxes, the county will take the property and sell it at a tax sale. Y'all trying to recover the taxes owed. But you would receive a tax deed. Now, I will tell you, if you ever decide to do this, you better do some research into this tax deed. I'm not going to get too into the weeds here. It's not necessary for what we're doing right now. But with that tax deed, you still have some limitations, especially and probably for up to about a year before you can do anything with that property, because the person that lost the property typically will have about up to a year to still come back and pay these back taxes and get the property back. There could be some issues with this. So, if you're ever going to mess with a tax sale, you better look into it deeply and understand how all this works. All we're trying to get you to see now is if you're the highest bidder at a tax sale, you're going to receive a tax deed. I can assure you there are no guarantees and warranties that come with that either. Then there's the trustee's deed. Y'all, when the deed is held in trust by someone, you see this from time to time within the loan process, where maybe instead of the buyer holding the deed to the property when they buy it, they allow some trustee to hold it. So the buyer or the new owner doesn't hold the deed, and neither does the lender. They'll have a trustee. So they call that a trustee's deed. You could use a bargain and sale deed. These are common with foreclosures. If you can't make your house payment, we've already talked about this a little bit, so this is hopefully just a review for you. But if you can't make your house payments, obviously you're not going to stay here, right? Especially if you owe money and you can't pay it back, you're going to have to leave. Now, the options I guess you have, you can stay there and fight it legally for as long as you can, but I will tell you, you're going to lose. Eventually, you're going to get kicked out of that property. Or you can avoid all the legal expenses and issues that come with foreclosure and just say, you know what, bank, I can't make my payments, lost my job, whatever, for whatever reason. You can just have the property. Here are the keys, you can have it. And what they would have you do is sign what they call this bargain and sale deed, where you're signing over the ownership, because it's a deed. So you're transferring the ownership from yourself back to the lender. Okay? So, this is something you tend to see with foreclosures. Then there's this thing called an executor's deed. But it said, this is a type of bargain and sale deed with a covenant used to transfer real property from a decedent's estate to a buyer. The features you see there, it authorized by the decedent, by their will or a court of law. let's see, falls under court-ordered deeds issued as part of the legal process and must state full consideration, the sales price and so forth. So, when talking about an executor's deed, someone named as the executor, whether it be because someone died and the person that died, the decedent, in their will appointed whoever to be the executor, and they could, if there's money owed on the property, and nobody wants to take over the payments, I guess, then the executor could sign it back over to the bank through this executor's deed. That's really all they're talking about there. And then there's something called a referee's deed. Again, carries no guarantees and no warranties. But you see this used a lot with bankruptcy proceedings. Occasion with foreclosures, it could be used there as well. But typically it's in a bankruptcy proceeding is where you probably see it most common, and it's kind of like someone is holding as the referee, and they pretty much decide who's supposed to get it and when. But again, there are no offers or guarantees with this one. So a lot of different types of deeds here. Make sure you understand. Well, you need to be familiar with all of them because they potentially could ask you about all of them. But remember the main two, at least in the traditional sense, practicing and selling of real estate, you're going to be dealing with either the general warranty deed or potentially the special or limited warranty deed. And then which of the deeds carries no guarantees and warranties? Obviously, several of these we just talked about carry no guarantees and warranties, but I can about guarantee you, if they're asking you that question, the answer they're going to be looking for is probably that quitclaim, because that's the most common. That's the reason I even say that. That's the most common. So those are your different types of deeds.